So I think we should start from your special contracts or something left. Something left?
No, sir.
Okay. Shall I discussed? Sorry. Had I discussed all the exceptions to the general rule that no consideration, no contract? Have I discussed?
Yes,
Yes,
sir.
sir. Consideration has been discussed.
No. No consideration, no contract. The exception to this general rule. There is a general rule that there no consideration, no contract. But to this general rule, there are certain exceptions. Those are coming under section 25 and section 185.
That is not discussed actually, sir.
Yes.
Not is discussed. Not discussed that thing.
Not discussed. Okay. So, please be attentive. Actually, okay, there is certain noise. Please try to resolve these issues. Okay. Generally, what it is accepted that if there is no consideration, then there will be no contract. But to this general rule, there are certain exceptions, and these exceptions are discussed under section 25 and section 185. So let us discuss the first one, that is section 25 subsection 1, which is natural love and affection. Okay, natural love and affection means actually if there is a written and a registered agreement and based on the natural love and affection between the near relatives, then it is enforceable, even if there is no consideration. For example, you can suppose a husband will make one written agreement to pay monthly 20,000 rupees to his wife. Okay, so here you see this agreement has been made on the ground of natural love and affection, and here this agreement has been made, but there is no consideration. Without consideration, this agreement has been made by the husband, so it can be enforceable in the court of law. Is that okay? You understand? It is coming under section 25 subsection 1. Is that clear? Not only wife, but with any near relatives. That means who are relatives, with them, if you enter into agreement on the ground of natural love and affection, you will make one agreement, then that shall be enforceable in the court of law. Okay. And regarding the second one, that is compensation for services rendered. Compensation for services rendered means past services rendered. It is coming under section 25 subsection 2. So a promise
Sir, again,
to pay
sir, please tell again. Compensation
for past services rendered. Compensation for past services rendered.
Sir.
Here you see, suppose a person will make a promise to pay for past voluntary services, then also it is enforceable. I am giving you one example. Suppose P finds the accused dog. Okay, P finds Q's dog and gives it to him. Now Q promises to give him 2,000 rupees. So here you see there is a no there is no consideration. Still then, as it is a past this type of service which is rendered voluntarily, for this also you can enter into an agreement and it can be also a valid contract. Okay.
Sir, no consideration means?
No consideration means here you see, suppose P finds the Q's dog. Okay, but at that time P was not in a good condition. That is a good financial condition. Then after 2 or 3 years, then P enter into an agreement with the. Yes, it is not audible.
It's not visible, sir.
Hello.
It's not visible.
Not visible. Visibility does not matter. Your understanding matters. Okay. you see, suppose what will happen, P finds Q's dog. But when P finds Q's dog, at that time, the Q's position was not good. Okay, financial condition. But after 2 or 3 years, then what happened? Q entered into an agreement with the P to pay what 2,000 rupees for this past service which is rendered voluntarily by what a P. Now this can be enforceable in the court of law. Although now there is no consideration among the what are these two parties. Is that clear?
Sir,
Yes, sir.
Okay. Now we'll discuss section 25 subsection 3, that is regarding time bar debt. Okay. Time bar debt means if the debt has been taken and after its time bar, then it becomes bad debt, as I told already. And this time bar debt, the party can also enter into an agreement to make the payment of a time bar debt, but it should be made in writing and signed by the debtor. Then only it can be enforced in the court of law. Although the in the present scenario, there is no consideration. Right. Next one is what a completed gift. If a person, this is coming under section 25 also, explanation 1 to the section 25, that if a person gives certain properties to another according to the provision of the Transfer of Properties Act, then he cannot subsequently demand the property back on the ground that there was no consideration. You understand? Suppose A transferred his property to B, right? As that means as a gift. As a gift, if he had transferred, and later on, if he demanded back the property back on the ground that there was no consideration, then it will not be tenable. That means if it is a completed gift, then it is what? There is a consideration. That means the gift is itself a consideration. Whenever someone giving something as a gift, then his consideration is the gift, right?
Yes, sir.
Okay, and the next one is your section 185, which is regarding the agency contract. Actually, under this act, or according to the section 185 of Indian Contract Act, no consideration is necessary in a contract of agency. That means, suppose if you appoint Mr. X as an agent, and the Mr. X, without taking any or without charging any commission or anything, works for you, then also it can be what attainable. That means it can be enforceable in law.
sir, not understood, sir.
Not understood. You see, in generally, agent means what we understand. That means they are representing their principal, right?
Sir.
So whenever the principal and agent they have entered into an agreement, they are what they may mention the consideration. That means it may be for a what that is commission or may not. There may be a commission or may not a commission. So if the commission has been mentioned, then it is okay. If no commission is also mentioned, then also it is okay. That means it can also be enforceable in case of a agency contract, right? It is one exception to the general rule that no consideration, no contract. Another that is a guarantee, which is coming under section 127. A contract of a guarantee is made without consideration. That means suppose one of your friend is in need of money and he applied a bank and the banker denies to give him the loan. And in the meantime, the banker said that if you will give guarantee, then the banker will give the loan. And now you have given the guarantee. But here, for giving guarantee, are you charging something from your friend? No. That means there is no consideration, but still it is a contract. Okay. Yes, yes. Am I audible to you?
Yes, sir.
Yes, sir.
So have you any doubt in this? A contract of a guarantee.
Sir,
Yes.
sir, again, please tell, sir.
Actually, you see, in a contract of a guarantee, if it is made without consideration, then also it is a valid contract. As for example, I have given, that means suppose your friend has approached a bank, particular bank, for a loan, and the banker denied. But the banker, they said your friend that if he will give guarantee, then the banker will provide him the loan. And now you have given the guarantee and the banker provided him the loan. That means there is a contract between the banker and you that you are giving the guarantee. And whether there is any consideration between the banker and you, is there any consideration? No. But without consideration, this can also be a valid contract. Is that right?
Yes.
Okay. Another is your remission, which is coming under section 63. So no consideration is required for an agreement to receive less than what is due. That means suppose 20,000 is due to you. Okay, 20,000 is due to you, and you are supposed to make me the payment of that 20,000. But later on, what happened? I have entered into an agreement with you that you can pay something less than that. So if you will pay something less than that, for that I am not charging you any consideration. That means here without consideration also this can be entertained. That means this can be enforced in the court of law. Is that clear?
Sir, what is the name of this section 63?
63, that is remission. Remission.
RE?
REMISSION, remission.
Remission means suppose A given 20,000 to.
So, suppose you see, you are supposed to pay me 20,000 rupees. And what happened in the meantime, I told you, okay, let us cancel that contract and I will receive something less than that. That means say 15,000. Now, for this difference amount, I am not charging any consideration. Okay, but still then this contract for the 15,000 is also a valid contract. Although there is no consideration. Why I have reduced that amount? That means this remission. That means if you will receive less than the amount and for that you will enter into a contract, what is exactly due to you, if you will enter into an agreement with another person for the lesser amount, then it is on the ground of a remission, which is coming under section 63, that can be also a valid contract. Is that clear?
Sir.
Okay. And the last one is that when the promise is for a gift or donation. Yes.
Sir, can you explain that section 127 once again?
Okay. Section 127, it is meant a contract of a guarantee. Contract of guarantee means what? Suppose just for example, you see whenever some persons are approaching the banker for loans, and the bankers, they are asking for guarantor. Guarantor, that means certain known persons. And if a known person is your friend, then you will approach him, and what will happen? That friend will give guarantee for you in the bank. That means the your friend will enter into an agreement with the banker as a guarantor, right? But there is no consideration in this contract. Is there any consideration? No.
No.
But this can be a valid contract, right?
Yes, sir.
Okay. And the last point is that when the promise is for a gift or donation, that means I will make a promise. I will make a promise that I will give you 5,000 rupees as a gift or donation. Whether it will be enforceable, I will enter into an agreement with you that I will give you a gift of 5,000 rupees.
No, 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 sir.
Obviously, this cannot be enforced. Okay, that means if we are making a promise to give further gift, that means this promise is baseless. That means in future you may keep your promise or may not. So it cannot be enforced, right? So these are the few exceptions to the general rule that no consideration, no contract. So consideration we have completed thoroughly. Any doubts in any point?
No, sir.
Okay, so let us proceed to the next, that is a special contract. In the special contract, actually, I told you in the previous class, there are three special contracts which will be discussed in under this Indian Contract Act. First one is your indemnity and guarantee, which is coming under section 124 to 147. And the second one, I think that is section 148 to 181, and the last one is 182 to 238, that is 238. So let us discuss the first one, that is
sir, please tell again, sir.
yes.
Please tell again.
Okay, so the
section.
Okay. That is under special contracts, the first one is coming, that is indemnity and guarantee. It is coming under
Indemnity.
section 120. Indemnity
Indemnity and guarantee.
and guarantee. So this is coming under section 24 to 147.
124 to
147 of Indian Contract Act 1872. Okay.
sir.
Okay. So
Yes, sir.
let us. Any queries?
Then next.
No, sir.
Next we will discuss. When we will discuss, I have 10 sections about that. So now we'll discuss, that is a section 124. Section 124 of the Indian Contract Act illustrates that a contract by which one party promises to save the other from the loss which is caused to him by the conduct of the promiser himself or by the conduct of any other person. It is called a contract of indemnity. That means in this type of a contract, actually what happens? One person promise, that means one party promises the other party to indemnify the loss. If there will be any loss, then first party will indemnify to the second party, and this loss which is sustained by the second party, it may be either due to the fault of the first party or of any other person, that means a third party. Then it is called a contract of indemnity. Able to understand this or any issues?
Sir,
No,
no,
sir.
sir.
1 second, sir.
Okay. Here you see, actually what is happened, this type of in this type of a contract, one party promises to another to make his loss good. That means if the second party will sustain any loss, then the first party shall make good that loss. Okay. And
Yes,
this
sir.
loss, which is this loss which is sustained by the second party, it may be due to the fault of the first party or due to the fault of any other party, that is third party. It is called a contract of indemnity. We understand? Or I shall give one example so that
Sir, one example, sir.
interruption? Am I audible?
Yes,
Yes,
sir.
sir.
Yes, sir.
Okay. So you understand this definition, or you need any example?
Sir, please example.
Okay, example. Okay. So you see, suppose Mr. X entered into a contract with Mr. Y. Okay, Mr. X entered into contract with Mr. Y to swim in a pond, right? To swim in a pond. Now, while swimming in the pond, if certain losses has been sustained by the second party, that is Mr. Y, then whatever the losses caused due to him, that means whatever the expenses of the hospital, all shall be borne by Mr. X. Okay, this type of a contract is called your contract of a indemnity. Now you understand it clearly?
Okay, sir.
Okay.
Yes, sir.
And
Yes,
what
sir.
type of contract it is? What type of a contract? Whether it is a quasi contract or any other type of a contract it is. Please think. Yes, any guess?
Express
It is,
contract.
yes, which type of a contract? It is a type of a contingent contract. It is a type of a contingent contract. That means this depends upon the happening or not happening of a certain event. If there will be no loss, or no damage or no loss sustained by the second party, then the first party is not supposed to indemnify anything. That is why it is it is a type of a contingent contract, and this contract can be express, or it can also be implied, right? The contract of indemnity may be expressed or implied. Is that clear?
Yes, sir.
Now let us discuss what are the
Yes, sir.
elements. Now let us discuss what are the elements of this contract of indemnity. Particularly this contract of indemnity, apart from other essential elements of a valid contract, two elements are most important. First, the indemnifier expressly promises to indemnify the indemnity holder. That means here you see who are the person. One is your indemnifier and another is your indemnity holder, right? And one is indemnifier, and another is indemnity holder. The indemnifier will expressly promises to indemnify the indemnity holder. Are you clear now? Who are the parties to this type of a contract? Indemnifier and indemnity holder, right? And here you see the indemnifier expressly promises to indemnify the indemnity holder. Here, and the second one, the promise is to protect the indemnity holder against the loss that could be the result of an act on part of the promisor himself or by it. So here the loss which is sustained by the by the indemnity holder, this loss may be due to the indemnifier or any third party. Is that clear? These are the two elements apart from all the essential elements of a valid contract. Is that clear?
Yes, sir.
So now let us discuss what are the rights of an indemnity holder. These rights of the indemnity holder are discussed under section 125. Okay, the rights of an indemnity holder. which is coming under section 25. The first one is right to damage. Right to damage. So an indemnity holder is entitled to recover the amount of damage that he has been sustained.
Sir, excuse me, sir. Sir,
Yes.
actually, why we are using word like indemnity in this law? So, can you explain why not other, not anything else?
You see, nowadays we are using insurance. Insurance is a type of a contract, that is a type of a indemnity. Okay, that means here you see one person enters into agreement with you that if you sustain any loss, then that party shall indemnify you. You can take the example of underwriters. Underwriters, you know, who are underwriters? Whenever there is a the company is in fear of losing their IPO, they are entering into contract with a third party, that is called what we are telling, that is exactly underwriters. And these underwriters, they are charging a commission that if the company is not able to receive its minimum subscription, then the entire holding shall be that means purchased by the concerned party. That means that underwriter. Are you clear now?
Yes, sir.
Why this
Yes,
is
sir.
important? Okay.
Yes, sir.
So first, right to damage I discussed, and the second, right to cost. Right to cost means what? If while going through the contract, that means according to the contract, if the other party is supposed to go through any legal procedure, then there will be cost. That is all the cost which is related. That means he will file a suit, and for this legal suit, certain expenditure will be incurred by him. Then whatever the cost he will incur for filing the suit, the entire amount he can claim. Okay, he can claim the entire amount of the cost. Yes, yes. Any issue?
No, sir.
Okay. Now we'll go to the third point. That is sum paid under the condition of a compromise. Sum paid under the conditions of a compromise. That is, here you see the indemnity holder is entitled to recover all sums which he may have to pay under the terms of any compromise of any such suit. That means whenever there is a legal suit, then the court may ask or may order for a compromise. And here in a compromise, if the indemnity holder is supposed to make any payment, then he has a right to claim that. Okay. So these are the what rights of your indemnity holder. What are these? First is right to damage, second is right to cost, and third is sums paid under the condition of a compromise. Are you clear?
Yes, sir.
Yes, sir.
Okay. Now we'll go to discuss that is rights of the indemnifier. These rights have been discussed under section 141. Okay, and various court verdict. Actually, you see, Indian Contract Act is silent regarding the rights of the indemnifier. But there is certain provisions are there under section 141, and various on the basis of various court verdicts, we can inculcate the rights of the indemnifier. So let us discuss them. The first one is that an indemnifier, after he has paid the damages under an indemnity, then what regains the right he had delegated to the indemnified. That means whatever he had given as a damage, whatever amount he has paid as a damage to the concerned party, only after making the payment, only after making that payment, then he can also file a suit against the concerned party to get that amount. But it is only after he has paid the damage and not before that. Right? It is one point. And another point is that the indemnifier has indemnified the indemnity holder. He gets the right to sue the third parties on behalf of the indemnifier. Okay, directly he gets the right to sue the third parties on behalf of the indemnifier. And the third point is that indemnifier is
Please,
not, yes.
Please, please, sir,
Sir,
explain with an example.
sir, it is not understood. One is indemnifier, outright indemnifier holder. So once after paying the loss of indemnifier holder, indemnifier can file a suit
Yes,
to recover his amount.
yes. But first is supposed to pay that damage, and after that,
Suppose indemnifier feels that the indemnity holder has wrongly taken the money,
yes,
then he will suit.
then only he will file a suit. But when he will file a suit, after paying the damages, whatever claimed by the indemnity holder, right?
But you are telling third party. Who is the third party?
I told you third party.
You told just now some third party.
That is in the another point. That is in another point. That is not in this point. In this point, I told after he has paid the damages under an indemnity, regains the right he had delegated to the indemnified. That means only after making the payment of the damages to the indemnity holder, if he has any ground to feel that the indemnity holder has exploited him or taken some more amount from him, then he can file a suit against that, right?
Sir.
Okay, and the second point is that if the indemnifier has indemnified the indemnity holder, then directly he can get the right to sue the third parties on behalf of the indemnified. Actually, who should file a case for the third party? That is indemnity holder. But here you see directly the indemnifier can also file a suit against the third party on behalf
Actually,
of, yes.
sir, who is the third party? That is the
Who is the third party? That means suppose I entered into agreement with you, okay, with you to make a dealing with any third person. So while dealing with the third person, you sustain certain loss. So now it is my duty, first duty, to make good that loss. After making good that loss, what I can do? I can file a suit against the third party also on behalf of you.
okay.
Okay. Okay. Then the next one is that if the indemnified suffers any damages which are not covered by the contract of indemnity, then the indemnifier is not bound by law to pay those damages. Suppose I have entered into an agreement with you so that to make a deal with any third party, but not strictly according to the whatever the terms and conditions of the contract. That means you have little bit gone beyond the scope of the contract and you have entered into agreement with the third party, and due to that you sustain any loss, then I am not legally bound to make good that loss. Is that clear?
Yes.
Okay. And the last point is that the indemnifier is entitled to sue third parties only to the extent of the damage he has paid to the indemnifier. Suppose loss was huge loss, but whatever amount the indemnifier has paid to the indemnity holder as damages, he can maximum sue for that amount, not beyond that. Okay,
Yes.
very good. Now we have discussed all the elements as well as the rights and duties of the indemnifier and indemnity holder. Now we'll go to the next type of contract, that is your contract of a guarantee. Okay, this contract of a guarantee is coming under your section 126 of the Indian Contract Act. So what is a contract of a guarantee? The Act defines a contract of a guarantee as a contract to perform the promise or discharge the liability of a third person in case of his default. In case of his default means, suppose you see, you have given a guarantee to the bank that if your friend will not able to close his loan, then you are giving guarantee to close that loan. Here you see, this is a type of a what, contract of a guarantee.
Sir,
Right.
1 minute. Sir, what is the difference between indemnity and guarantee?
You see, in the indemnity, there is what, according to your direction, the another party shall enter into contract with another third party. That means the first, according to the direction of the first party, the second party enters into contract with the third party. Okay, and whatever the loss borne by the second party due to the first party, that loss shall be, or that damage shall be what, recovered from the first party. This is a contract of indemnity. And in the guarantee, what is happened? Only on the default of the first on the default of the second party, that means the person for whom you are giving the guarantee, you are liable. You can take the example of a bank. Suppose a banker will give a loan on the basis of your guarantee to Mr. X, right? Mr. X is your friend. Now, if Mr. X will pay the entire amount, whatever loan taken by him from the bank, if he will settle the entire amount, then no matters. There is no liability, particularly for you. But if your friend fails to make the payment, then you are liable to make the payment. Is that clear? This is a contract of a guarantee.
Sir.
Now you are very clear regarding the technical difference between both type of a contract. Okay. Now you see, here in a contract of a guarantee, there are three parties. That is why it is called a tri-party. Okay, tri-party contract. Generally, if somebody will tell what is a tri-party contract, then that means you should understand that it is a contract of a guarantee. Here, three parties are concerned. The person who gives the guarantee is called the surety. The person who gives the guarantee is called the surety. And the person in respect of whose default the guarantee is given is called the principal debtor. Principal debtor. And the person to whom the guarantee is given is called the creditor. Now you take the example of that bank loan. Here, you are the surety and your friend is the principal debtor and the bank is the creditor. Now you understand?
Yes.
Who are the three parties? Okay. And the contract can be oral or can be written. Even it may be also expressed or implied. Even it may be expressed or implied. One example is given. A advances loan of rupees 50,000 to B and C promises to A that if B does not repay the loan, C will do so. This is the example of a contract of a guarantee. Here, your B is the principal debtor, C is the surety, and A is the creditor. Right? Able to understand it clearly? This is a tri-party agreement. Okay.
Third party, this guarantee, third party will be the third person will be the guarantee of the contract.
party shall be the
third person be the guarantee of this contract.
that third party who will give the guarantee. He is called the surety. He is called the surety. And the person in respect of whose default the guarantee is given is called the principal debtor. And the person to whom the guarantee is given, that is the creditor. Is that clear? So in this particularly, as I told you, that it is a agreement. That means it is what 3 agreements will be there. In this contract, 3 agreements will be there. One agreement is between creditor and a principal debtor. Another agreement is between the surety and the creditor. And another will be between the surety and the principal debtor. Right? It is a tri-party agreement. That means these 3 agreements are part of that contract. Is that clear?
Sir.
Yes.
So what is the objective of this type of a contract? Whenever we are making this type of the contract, what is the basic objective behind that? Basically, there are 3 objectives. First, the security of a loan, which is given to a party. Okay. Second one, assurance of good conduct and honesty of an employee in service contracts. Whenever there is any service contract, then also they need any assurance of a good conduct. Okay, and honesty of an employee in service contracts. And indemnity of a third party is that is to indemnify of a third party from loss resulting from the non-payment of a debt. Suppose the banker will give a loan amounting to rupees 50 lakhs to your friend, and your on the failure of your friend, the bank will not sustain that loss. That loss will be borne by you. Okay, that means the banker will save himself from the loss resulting from this loan. Right? So these are the basic 3 objectives or purpose of the contract of the guarantee. Now let us discuss what are the essential features of a contract of a guarantee. The first and most important feature of this type of a contract is that existence of a principal debt. Existence of a principal debt, that means there must be certain debt which is supposed to be repaid. That means if unless there will be a bank loan, so there is no necessity of a bank guarantee. Or unless there is any amount to be paid or to get, then there is no case of a guarantee, contract of a guarantee. That is existence of a principal debt. And the second one is a benefit to principal. Yes.
Sir, it is not understood, sir, actually.
Not understood. That means if there will be no debt, if there will be no debt, if there will be no debt, then why there will be a necessity of a contract of a guarantee? Contract of a guarantee is not required. Contract of a guarantee is required only when there is a debt. Okay, for the purpose of a clearance of the debt, only this contract of a guarantee is useful. Right?
Okay.
And the second is that benefit to principal debtor is a sufficient consideration. In this case, particularly in a contract of a guarantee, you see there is no consideration is directly flowing from the surety to the principal debtor, right? From the surety to the principal debtor, no consideration directly. Hello, am I audible?
Yes.
So have you understood it?
No, sir.
Okay. You see what is happening. The benefit to principal debtor is sufficient consideration. That means if you are giving a guarantee to the bank so that the bank will forward a loan to your friend, then the benefit to your friend is sufficient consideration. No other consideration is directly flowing either from the bank or from your friend to you. Is any other consideration is flowing directly? No?
No.
Okay.
No, sir.
Namaskar. Hello.
No, sir, କହିଲେ।
Okay.
Sir, please continue, sir.
Okay. I have discussed the second point, that is benefit to the principal debtor is sufficient consideration, which is coming under section 127. Now we'll discuss regarding the consent of surety not obtained by misrepresentation or concealment. Consent of a surety not obtained by misrepresentation or concealment. That means in a contract of the guarantee, it is the duty of principal debtor or the creditor to explain in detail regarding the liability of not settlement. That means whenever the surety enters into a contract, what shall be the legal consequences? This should be very clear before entering into contract. That is why the consent of a surety should not be obtained by misrepresentation or concealment. That means it is the duty of both the parties, that means the principal debtor as well as the creditor, to mention clearly regarding what is liability of the surety. Is that clear?
Yes.
Okay. And the next point is that a contract of a guarantee may be either oral or written. It may be also expressed or also implied. Right? And the next point,
Sir,
surety
but
can
in bank, in verbally they will not accept the surety, na?
Actually, they are not accepting it. But if you have made a certain oral agreement and in the court of law, if they will produce evidence that orally you have admitted that, then also it can be a valid contract. Okay.
Okay.
Then surety can be proceeded without proceeding against the principal debtor first. That means, suppose if you have given a guarantee for your friend taking a loan from, so if your friend fails to make the payment, then it is your first duty that you will make the payment to the bank. And after making the payment to the bank, then you can proceed further. That means you can file a suit against your friend to get that amount. Okay. But first, it is your first duty that you should make the payment to the bank, because the banker will take the money from you on failure of your friend. Is that right?
Yes.
And a contract of guarantee can only be between at least three parties. I told it is a tri-party contract, and there are three parties concerned. The party is surety, second is your principal debtor, and third is a creditor. And here you see, pre-consent of all the parties is essential for a contract to be valid. That means if any party proves that his consent to the contract has not been taken freely, or is affected by coercion or undue influence or something like that, then the contract may be become voidable at the option of the affected party. Okay, so I think the time is over, or another teacher who will take the next class join the class.
Okay, sir.
Okay, so I think tomorrow morning also we have a class. So we'll discuss the next thing, that is distinction between indemnity and guarantee, in the next class. Anybody having any doubts or issues, whatever we had discussed?
Sir, hello.
Yes.
Sir, I want to confirm one thing. What we are discussing till now, it all are the sections of Indian Contract Act.
Yes, all are from Indian Contract Act.
Okay,
But
sir.
these,
Thank you, sir.
but these are your special type of a contract: indemnity, guarantee, then bailment and a pledge, then agency. These are what a special type of a contract. But these are all parts of the Indian Contract Act.
All these are derived from Indian Contract Act.
Yes, 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 yes.
Okay, sir.
Okay.
Thank you, sir.
Okay. Thank you.
Thank you, sir.
Thank you.
Sure.
Thank you.
Thank you, sir.
Thank you. Shall I make the host to somebody, or your classes will be resume now?
Sir, it will continue.
It will continue. Then I
Yes, sir.
need to make host to somebody.
Yes.
Okay.
You can make, sir, DDC, someone from DDC to me.
I'm searching whoever the DDC person is there.
Host? Acha.
On the name of management.
Now business ethics class is there.
Business ethics class. But I'm not finding the teacher. And management is also not there.
Sir, you can end the session. Next, sir can initiate. There is no issue.
Okay. Okay. Okay, so I'm ending the session.
Yes, sir.
Yes, sir.
Thank you,
They will
sir.
share the new session
Yes,
link
sir.
for joining.